It may surprise you that the likelihood of a person being released from custody on bail can differ between different states and territories. We've seen reforms recently announced in states like New South Wales, sparked by community outcry. Last week, the New South Wales government proposed laws to reverse the presumption of bail for serious domestic violence offenders. This means they'll remain behind bars unless they can show why they should be released. The state also wants to introduce ankle monitors for alleged offenders who are successfully granted bail and released into the community. In Queensland, these laws are already in place. Anyone charged with a serious domestic violence offence has to convince a magistrate to grant them bail. Ankle monitors are also in use as a condition of bail in the state. In the ACT, alleged offenders cannot be granted bail unless a senior police officer or magistrate is satisfied they do not pose a danger. Over in Victoria, bail is granted unless the courts believe the offender poses a safety threat. Recent reforms decriminalised breaches of bail, which concerns some advocates, but police say magistrates can still revoke it. The government wants to give police extra powers to ban offenders from interacting with victims by making the current 14-day family violence safety notice permanent. In the Northern Territory, alleged offenders with a history of violence or previous breaches of a domestic violence order must prove they don't pose a further threat before they're granted bail. Those without a history are granted bail unless prosecutors can prove they would be a threat. In South Australia, an alleged offender is granted bail unless charged with either a serious domestic assault, breaching a condition of bail in place to protect a victim, or breaching an intervention order. In Western Australia, family violence offenders aren't given bail except in exceptional circumstances, and if bail is granted, the court must get a home detention report and electronic monitoring is considered as a condition. Over in Tasmania, someone charged with a family violence offence won't be granted bail unless the court is satisfied they would not be a danger to the victim. In 2018, electronic monitoring was introduced for those subject to a family violence orders. While these laws do vary across the country, at the recent National Cabinet meeting, leaders agreed to improve information sharing and strengthen consistency. They remain under the spotlight with pressure from the community to better protect victim survivors.